Hello and welcome. Whenever you switch your job, I'm sure you would have heard of the phrase notice pay recovery. When you put down your papers, that is when you resign, you are required to work for a fixed number of days, usually 30 days, and this is known as the notice period. We all know about this. If you don't serve this notice period, then your employer can recover money from you, which is known as notice pay recovery. Say for example, your notice period is 30 days, but you have worked only for 20 days. So your employer can deduct salary in respect of the remaining 10 days. This notice pay recovery clause is usually included in your employment agreement. If you have thoroughly gone through your employment agreement, I'm sure you would have come across this particular clause. With the introduction of GST in July 2017, we were told that employment services, that is services by the employees to their employer, is outside the purview of GST, that is no GST on salary. Because of this reason, employers neither collected nor paid GST on notice pay recoveries. But GST department started issuing notices demanding GST on notice pay recoveries. This led to a lot of confusion in the corporate world, and some employers started even collecting GST on notice pay recoveries. Thankfully, in August 2022, CBIC, that is Central Board of Indirect Taxes and Customs, has come up with a circular clarifying applicability of GST on notice pay recoveries. The crux of this circular is GST is not applicable on notice pay recoveries, so employers are not required to collect and pay GST on notice pay that is recovered from their employees. But if you would like to know the reason why CBIC has come up with this circular, you may consider watching this video till the end. In this video, we are going to discuss about this circular in detail and understand the reason why the CBIC has issued this circular when its own officers had a different view. But before we start analyzing the contents of this circular, we need to understand the meaning of certain words, starting with the word supply. The meaning of the word supply is given in section 7 of CGST Act, that is Central Goods and Services Tax Act. Key things to note here are: supply includes all forms of supply of goods or services or both for a consideration. Let us quickly understand the meaning of the word consideration. Consideration in simple words is the money that you receive for supply of any good or service. So whenever there is a supply of any good or service and you receive money, such transactions would be considered as supply, and once a transaction is treated as supply, GST would be applicable. Now let us apply the meaning of this word supply to the salary that you get from your employer if you are employed. Now money received here, that is the salary here, is the consideration for employment services, that is services that you provide to your employer. So we can safely say that this is a supply from the employee to the employer. And once a transaction is treated as a supply, then GST would be applicable. But have you ever paid GST on the salary that you get from your employer? No, this is because of Schedule 3 of CGST Act. Now, Schedule 3 lists out certain activities or transactions which are neither treated as supply of goods nor as supply of services. And one of the transactions listed out here is the services provided by an employee to the employer. Because of this exclusion, GST is not applicable on salary. That's why you don't pay GST on the salary that you get from your employer. So far we have completed one part of our discussion. Let's now move to the other part, that is notice pay recovery. Here money is paid by you, so receiver here is your employer, unlike salary where you are the receiver. So this Schedule 3 exclusion is not going to be applicable here. So if this exclusion is not applicable, then such transactions would be considered as supply, and if it is a supply, then GST would be applicable. It is because of this reason GST officers were issuing notices demanding GST on notice pay recoveries. But then why did CBIC come up with this circular saying that GST is not applicable on notice pay recoveries? Let's understand that. For the sake of argument, let's say that the money that is received by the employer, that is the notice pay recovery, is the consideration. If so, what is the supply here? Has the employer supplied any service to you? Have you got anything from your employer? No. But you can argue that because of this notice pay recovery, you got your full and final settlement, you got your experience certificate, relieving letter, etc. So that is the service for the notice pay that is recovered by your employer. Think for a moment, had you not got this full and final settlement, certificates, etc., if you had served your notice period? Even if you had served the notice period, you would still get this full and final settlement and other certificates. So we can't say that issue of this certificates and full and final settlement is the service that is provided by your employer for recovery of this notice pay. So we can conclude that the employer has not provided any service for the notice pay that is recovered. So if it is not a service, then whatever money that is received by the employer cannot be treated as consideration. If it is not a consideration, then what is it? Notice pay recovery is the money that your employer recovers from you if you don't serve the minimum notice period. It is something like a fine or penalty which is included in your employment agreement itself. Now, if you dig deep into this issue, the next question that would come to your mind would be, why do you have to serve this minimum notice period? Whenever you are hired, this hiring would involve a selection process. That is, you are selected after you attend several rounds of interviews. And for this, the employer is required to spend money not just on your recruitment but also to train you. And this is done on the assumption that you would work in this organization for a certain minimum period. If you suddenly leave the organization, obviously this would lead to some disruption of work. Also, your employer would require some time to make alternate arrangement, which usually happens during the notice period. So what CBIC in its circular states is that this notice pay recovery clause is included in the employment agreement to discourage people who are not serious about their job from taking up employment. So this is something like a fine or penalty. So it cannot be treated as consideration because the employer has not provided any service. When there is no consideration, there is no supply, and if a transaction is not a supply, then GST is not applicable. Before we wrap up, let me quickly summarize what we have understood so far. In the GST law, for any transaction to be treated as a supply, there has to be a supply of good or service for a consideration. That is, you should have supplied any good or service for which you either have received money or you are going to receive the money in future. If we apply the definition of this supply to notice pay recovery, here money is received by the employer, but the employer has not supplied any good or service. When there is no supply, the money received cannot be treated as consideration. When there is no consideration, there is no supply. When the transaction is not a supply, then GST is not applicable on notice pay recoveries. Hope the concept is clear to you. If you are an employer, then you don't have to collect and pay GST on the notice pay that you recovered from your employees. Similarly, if you are an employee, then you don't have to pay GST on the notice pay that is recovered by your employer. This is all I have for you today. Hope this was helpful. Thank you for watching.